Dear colleagues, we continue. Ukrainian Association of International Law continues a series of online briefings on different problematic of international law. This series was caused by quarantine and inability for all of us to communicate in person. And today we are turning to a topic that is especially close to Ukraine, and also it attracts, I suppose, more and more attention of the world legal practice. Some time ago, Ukrainian Association of International Law addressed the issue of correlation and connection between international public law and international private law. In particular, we plan to disclose the connection between these two aspects, the connection of these two domains and these two fields, which were regarded mostly as separate domains in international law. Also, we are planning to hold a conference on the interaction or correlation between public and private aspects of international law, but that is the issue of our future. So today we are taking probably the first step toward this huge problematic, and we propose to identify public law and private law elements of such an institution as jurisdictional immunities of states. This is an institution which is really connected with both public and private aspects or elements of international law. And now I'm especially glad to welcome our distinguished guest, Mr. Robert Shaw, who is partner in Holland and Knight's Boston office, Mr. Oleksandr Girenko, who is Ukrainian diplomat, and our colleague and first Vice President of the Ukrainian Association of International Law, Professor Mykola Gnatovskyy. Thank you very much for your participation and for your that you agreed to take part in our present briefing. And my special thanks to Dr. Svitlana Starosvit, who agreed to moderate this briefing. So in order not to delay our discussion, I would give the floor to moderators. So Svitlana, the floor is yours, please.
Thank you, Olga. Good afternoon or good morning, depending on from where you are joining us today. Welcome to the online briefing of the Ukrainian Association of International Law. As Olga has already mentioned, our topic for today is jurisdictional immunities of states, public and private law challenges. Thank you for joining us. We have a fantastic panel of speakers. Before we begin, a couple of reminders which go with any online event these days. Please keep your mics on mute all the time. Please use chat to ask questions during each speaker's presentation if there is something you want to address immediately. But also, please keep in mind that after we are done with the presentations, we will open the floor to the Q&A session. And you also will be able to ask a question or comment on what has been said in person, or at least so we can see you. Each speaker will have up to 15 minutes. At the beginning, we also discussed the option of kind of the possibility cutting into 10 minutes. So I would suggest let's see how it's going, okay? Because kind of the presenters, I think they were ready to give the presentation after 15 minutes. But of course, let's see. So let's kind of make it 10, 15 minutes. I will be sending you messages in chat closer to the end of your time, which I hope will help you to manage the time accordingly. Also, please be advised that the session is being recorded, so please keep your videos on if this is possible so we can see your faces. Now, before I give the floor to our wonderful presenters, please also let me say a couple of words on why the Ukrainian Association of International Law has decided to focus on this topic in the first place. There are a number of reasons for that, but I'll just briefly mention 3 of them, which I also hope will boost the discussion. So the first reason is that it's well known that Ukraine used to adhere to the to the traditional doctrine of sovereign immunity as a legacy of Soviet past. However, with Ukraine's independence, and of course, as Ukraine became the participant of global economy, or at least aspired to be one, certain provisions were included in a couple of statutes and in a civil code, but it's not a secret that the issue of sovereign immunity from jurisdiction is not well settled and is not well regulated at this moment. And there were a couple of attempts to change this. In 2015, the certain bill was introduced to the parliament, but it has never been properly considered, unfortunately. The attention to this topic, I think, renewed in 2019, at least within the legal community, if not within Ukrainian policymakers, when the Ukrainian Supreme Court upheld an order for enforcement of an investment or betrayal award against the Russian Federation on the basis of the waiver exception from the immunity from execution. This case got various reactions from the Ukrainian legal communities. Some praised it, some did not. So I hope that we will be able to talk about this case during our today's briefing. But most importantly, the case reminded us once again about the need to focus on this topic more closely and consistently by the Ukrainian policymakers, and of course Ukrainian legal scholars can contribute a lot, and especially certain work has been done already, and we are very happy to have with us the person who pioneered this field academically. The second reason is that over the last 3 decades, and especially over the last decade, Ukraine faced a number of suits in various foreign courts. And we believe it's time to reflect on this experience a little bit. We will not be able to cover all the cases, unfortunately, where Ukraine has been a defendant, but we will focus what we hope on the most interesting cases and on the most interesting jurisdictions so far when it comes to the questions of exceptions from jurisdictional immunities. And finally, as Olga has already mentioned, so I'll just add quickly that this topic is of huge interest for any state which is part of global economy and legal order. So it's hard, of course, for international legal scholars and for Ukrainian legal scholars to remain outside of the discussion when states keep arguing on the exceptions to the jurisdictional immunity, on their scope or on their application. So we also hope that we will see this in today's briefing as well. So the Ukrainian Association of International Law is happy to provide the platform for this discussion, and thank you for joining us once again. So if there are no questions with this broad agenda in mind, I think what could be helpful for us is to first step back and reflect on how the law on jurisdictional immunities, and especially its contemporary contours, were born out of the complex and long-lasting interaction between public and private fields, laws. So it's obvious, I think, for any scholar that these two spheres are quite challenging to keep neatly apart theoretically, and that is why our topic for today says it's about public and private challenges. With the growing role of states in commercial activities globally, the distinction between public and private kind of blurred. So to help us with this broader view, and to help us understand the theoretical dimension of the topic which we are discussing today, I think everybody will agree that Professor Mykola Gnatovskyy is best positioned to reflect on the complex interaction between private and public law in the field of law and jurisdictional immunities, and will also help us to introduce to the topic of today's briefing. Professor Gnatovskyy does not really need any introduction in the Ukrainian legal community, but for the sake of formality, is vice president of the Ukrainian Association of International Law, and he was elected 3 times of the much for joining us today, Professor Gnatovskyy. And without any further ado, the floor is yours, please.
Thank you very much, Svitlana. It's a huge pleasure to see you, at least online. So I'm already very grateful to the president of our association, Professor Olga Butkevich, for initiating this briefing and for choosing the topic, and also for the suggestion of our moderator. So it's a great pleasure to see you, Svitlana. And also, I'd like to say that I'm very glad that this topic is being discussed, and that this topic is really in the center of our attention today for various reasons. And I think Svitlana has very clearly outlined the main reasons for this. For me personally, jurisdictional immunity of states has been one of the most fascinating subjects in international law. I must say that I didn't really write a lot on it, even though I had to study it for some time, and also for some practical reasons. And I've been always fascinated about its complexity, about the way how it somehow pushes the boundaries and pushes the limits of knowledge and of specialization of lawyers, because we tend to compartmentalize our profession, and we tend to become narrower and narrower specialists in certain things. But the topic of jurisdictional immunities of states is one of those topics where almost every international lawyer has to say something at one point or another, and in his or her career, which is why actually this is a topic which is one of the richest in terms of the available doctrine internationally. So essentially all major international lawyers said something about it. They were usually doing this because their own states were asking them to assist in certain matters, and of course they didn't limit their participation just to pleading before a court, but also wrote a lot of interesting things about it. So as Svitlana has said, my task is rather modest. We have two very interesting and I think very practically oriented presentations ahead of us, and my task is rather to introduce the topic more sort of at a theoretical level. And because this is an event organized by the Ukrainian Association of International Law, I think I need to spend just a minute on explaining where I'm coming from here, because in Ukraine, which has its School of International Law pretty much originating at least in the recent decades from what remained of the Soviet School of International Law. The topic of jurisdictional immunities of states and their property somehow was left out for some time, because it wasn't really seriously considered by scholars in private international law, except for of course for the codification of private international law in Ukraine, and this topic, and basically the main substantive rules that we have now in Ukraine's law can be found in the Ukrainian law on private international law, particularly in Article 79, but of that law. But also it didn't receive enough attention from public international lawyers, because somehow it wasn't in the Soviet tradition of international law to address this topic directly. So it basically hangs somewhere in between. And of course, there have been a few people who wrote fairly good books on the subject, but still the topic didn't really receive enough attention. And as you mentioned, Ukraine has regularly faced various challenges to its own immunity in various fora internationally. So, coming back to my first statement that jurisdictional immunity of states is one of the most fascinating subjects. Well, theoretically it is, because it is all about intersections, and we love intersections. Various conflicts of law. This is something that is really very, very interesting to all. So it is at an intersection between international law and domestic law. It is, in fact, one of the clearest manifestations of international law in any domestic legal order. Of course, it stems from a substantive rule of international law, from the principle of sovereign equality of states, it manifests itself in procedural rules of domestic law, the way it is organized in various international orders is also rather interesting, because some of them prefer to codify various rules on foreign state immunity, whereas others rely mostly on the general provisions of their codes of civil procedure, and then essentially on the jurisprudence of their national supreme courts. It's also about conflicting ideas of public law and private law, because certainly states, as Svitlana has mentioned, are indispensable participants in international trade and in various relations in various transactions of purely commercial nature, whereas they still remain states, and they would like to still claim all the benefits they can get from the fact that they effectively are public international law subjects. The topic is also very interesting for a number of other reasons, and for those colleagues who specialize more on international law, I will just briefly say that it's very interesting how customary international law, not just international law, but customary international law, manifests itself in a domestic legal order. It's not just a problem that Ukraine faces, it's a problem that actually most legal orders internationally face, is that their constitutional provisions are not quite clear as to how they treat customary international law. Of course, the matter has been codified at the European level in 1972, the European Convention, and of course the 2004 UN Convention, but neither of them have entered into force, and neither of them are awfully popular among states. So it is essentially a customary rule. Then, of course, for those who study international law, who are interested in how those customary rules are created, it's fairly interesting to trace the national practice, how that national practice is crystallized, how this national practice meets the requirements that are generally set in international law for the creation of customary norms of general international law. As I mentioned already, there's extremely rich doctrine, and also there is something one also must take into account, is that in the 21st century, we now have sufficient international jurisprudence behind all these discussions. So it's not just doctrine, it's also judgments of international courts. Quite interestingly, at the European level, there is a very significant body of jurisprudence on the matters of state immunity coming from the European Court of Human Rights in the last 20 years, starting from the famous 2001 judgment, the three judgments, the Oleksandr, Fogarty, and Mykola. And then the doctrine and also its development in customary international law has never escaped attention since 2001 of the European Court of Human Rights, in the context, of course, of the right to a fair trial, because we're talking about a bar on access to the court, a bar also to enforcing the court's judgments. And since 2012, we also have the benefit of a very interesting judgment of the International Court of Justice in the jurisdictional immunities case, Germany versus Italy, with Greece intervening, which I think has also at least made a claim, if not solved the debate, the classic debate about the absolute and restrictive doctrines of state immunity. I don't have to, and neither there's time, nor I really have to specify and talk at length about those doctrines. As Svitlana mentioned, the absolute doctrine, the doctrine emphasizing the sovereignty of states and the impossibility, the exclusion of any possibility to address a court, address a state in a domestic court, let alone to enforce a judgment against a state. That has been the predominant doctrine, not only in Ukraine, but of course in the former Soviet Union and Ukraine. That was clearly the case. And it's also interesting that the opposing doctrine, the so-called restrictive doctrine of state immunity, whereas the distinction is drawn between the public and private law acts of state and confining immunity only to public acts, that doctrine has been treated rather suspiciously by a number of states, which is why actually the UN Convention based on this doctrine is not so popular and has yet to enter into force. And the reason for this is of course that states are first and foremost afraid that reciprocally their own immunity is not going to be respected any longer in the states, in other states, if they don't do it at home. So these are sort of very basic, very primary considerations that are very much valid now. And the ICJ judgment in Germany versus Italy, I think, is particularly notable because in a way, it can be read as advancing an alternative model of state immunity, the purely procedural model, basically emphasizing on the fact that the bar of immunity is simply a procedural obstacle to reviewing any acts, any violations of its obligations committed by another state in domestic courts. So no matter how serious the violation is, no matter how serious, how grave the matter is, it can be like in the Germany versus Italy case, well, it can be war crimes. So this can really be even violations of peremptory norms of international law. That doesn't really matter because there is a procedural bar, and this is something that the ICJ used previously in other contexts. For example, in the 2002 arrest warrant case, where a completely different question of immunity from criminal proceedings was at stake. So, and this is actually compatible with how the European Court of Human Rights sees this in terms of the right to a fair trial. In other words, the subject is very vibrant, and the interesting part here is that there's plenty of nuances, there's plenty of various aspects where the debate is active, where relevant courts have anyway they can really take one side or another. So this is something that I think is very beneficial for any lawyers who specialize on the subject. And of course, what's happening now in Ukraine, already alluded to by Svitlana, in Ukrainian courts with the jurisdictional immunities, especially of the Russian Federation, is something that is very remarkable and also requires a separate discussion. Let me stop here, and I'm looking forward to the next presentations and also to the ensuing discussion. Thank you very much.
Thank you, Professor Mykola Gnatovskyy. Dear colleagues, are there any questions to Professor Gnatovskyy? There are no questions in the chat. So Professor Mykola Gnatovskyy, thank you so much for this wonderful introduction. And you mentioned that in your presentation that the jurisdictional immunity is interesting for any international lawyer for a number of reasons. But the first and foremost reason is that it's a very interesting site for forming a custom, an international legal custom. So if anything interesting is happening in international law in terms of custom formation, there are not so many fields this day where we can really elaborate on state practice and to discuss what is a custom and what is not, which practice which practice is universal or just regional. So with this in mind, I cannot help but ask you, and of course, relying on the famous Ukrainian Supreme Court decision, because apparently, and we can discuss this case in more details, but apparently what is so obvious in this case for many of us and for many international lawyers who are interested in the formation of custom and using custom in judicial practice, the Ukrainian Supreme Court really struggled, of course, in finding the legal basis, the persuasive legal basis to uphold the immunity of the Russian Federation from execution in this case. On the one hand, we cannot blame the Ukrainian Supreme Court because really our statutory materials and civil code are kind of limited for the clear guidance. But as international lawyers, we know we have custom. And this is, of course, an internal question in the Ukrainian legal academia and also among the judges, is why not to, or why to rely on the custom as the source of law in the Ukrainian courts? Is there any, in your view, any legal valid reason not to rely on custom, on international custom directly? Because what the Ukrainian Supreme Court did, tried to bring the custom only through the ICHR practice, the fair trial cases, which you've mentioned, but it really shied away from just saying, okay, this is international custom and we are applying it. Are there any valid good reasons for this? Thank you for your reflections.
Thank you very much, Svitlana. The question is extremely interesting, and I would immediately suggest that we organize a special briefing on customary international law in the Ukrainian legal order. Seriously, because it merits a long discussion. In a nutshell, the Ukrainian constitution may, I would say may, does not have to, but may be interpreted in a way that allows the courts to use custom. And to apply custom directly. In particular, such reading of Article 18 of the Ukrainian Constitution is possible. Well, the article basically refers to generally recognized principles of international law, i.e. custom, essentially. Okay, it limits its application only to foreign policy, but whatever is happening to a foreign state in Ukraine, for example, with the jurisdictional immunity, is certainly has this aspect. So this is a possibility. It is rather funny that Ukrainian courts see no problem to apply a sort of jurisprudence of the European Court of Human Rights as a source of law, because this is what Ukrainian law on the ECHR judgments of 2006 says, rather clumsily, but this is what it says. And then they have to use the ECHR judgments to apply customary rules of international law, which are directly binding for Ukraine as a state. So this is certainly legally, this construction must be criticized rather severely. So this is a problem. Let me just give you one example to see the complexity of how customary law is difficult to apply in Ukraine. I recently read a conclusion of one of the committees of the Ukrainian parliament. The conclusion dealt with the draft law on amending the criminal code in accordance with contemporary international criminal law, essentially. And it said, the committee says, because the authors of the draft law rely heavily on customary international law, and they suggest that the courts will be able to apply customary international law, they create corruption risks, because customary international law is something very unclear and can be interpreted any way one likes. So this would be a temptation for any some corrupt actions by Ukrainian courts. A complete nonsense, utter nonsense in my view. But anyway, this is how learned lawyers in the parliament sometimes perceive international custom. So there's a long way to go here.
Okay, thank you, Mykola Mykolaievich, for this wonderful answer, and I agree that this is something to keep in mind, because like this is a perpetual conflict of how to apply or whether to apply customary international law directly in the Ukrainian court. So I hope that maybe at some point we will be also able to have a briefing or to hold the briefing on this particular issue, because I think it's enormously interesting. Dear colleagues, any other questions to Professor Gnatovskyy before we move on to our next speaker? Okay, I guess there are no more questions, but as a reminder, please feel free, if something comes up, please feel free to use chat to ask questions. And I think that nothing really stops you from asking questions to any of the speaker as we go. So if this is something you wanted to ask Professor Gnatovskyy, you always will have a chance to do that. And so speaking about custom and speaking about the state practice and speaking about how the restrictive theory of sovereign immunity can, could, should, would work in practice, I think that we can a very unique opportunity to look at this question today more closely by exploring the US practice as an example, with a lawyer who has extensive experience of representing foreign states in the United States courts. Robert Shore, partner in the Boston office of Holland and Knight, has joined us today. Welcome, Robert, to the Ukrainian Association of International Law, and thank you for joining us. So on behalf of the, I hope on behalf of the on the community of international lawyers, I will address a couple of questions for you, which I hope is of interest to everyone. The first question is of a general nature. How is the question of jurisdictional immunities regulated in the United States? Is it court practice or the statute or a combination of both of them? So I think that this will be very interesting for us to know, since we are in Ukraine are thinking of the best way to make this move from the absolute to restrictive immunity in our jurisdiction. The second question, I think, which also I hope is the interest for all of us, is how did it work for Ukraine as defendant in the United States? We know that Ukraine has been sued a couple of times. So if you can share with us what were the grounds for asserting the jurisdiction against Ukraine, were these attempts successful? It will be very helpful for us to understand what is happening in the US courts. And finally, I cannot help but ask you about any emerging trends in the sovereign immunity law in the United States. As for us international lawyers, the US is of course part of state practice, which potentially may form an international custom. So for this reason, we are interested in keeping our eye on what is happening globally, and of course, what is also happening in the most litigious culture, if I may say so. So Bob, thank you so much for joining us again, and the floor is yours.
Thank you, Svitlana, and thank you everyone for allowing me to address your important association at this important time. I'm Bob Shaw, and over the course of the last decade, I've been honored to represent Ukraine in 4 lawsuits in the United States. And today I'd like to give you a little bit of background on the unique way that the United States approaches the sovereign immunity question and share with you a little of my experience defending Ukraine in American courts. So we have to start back in 1812, when the Supreme Court of our country issued a decision that held that sovereigns had absolute immunity from suit in the United States. So the doctrine started in the courts, not in the legislatures. It was a clear-cut rule. It was easy to apply. And, back then, of course, the United States was a small country surrounded on both sides by oceans. There just weren't a lot of occasions that could give rise to claims against other governments. But over time, of course, the United States and its citizens started interacting more and more with other governments. And claims started to be filed, sometimes very strong meritorious claims. And courts started carving out exceptions to the absolute immunity of foreign states. And that started to interfere, of course, with the United States' diplomatic relationships. So the State Department stepped in. So for about a century, sovereign immunity worked like this. A plaintiff would file a case against a foreign sovereign in an American court. And the sovereign would run to the US State Department and ask for it to grant a suggestion of immunity. The State Department then had practically unfettered discretion to decide whether or not the case could proceed. It could kill the lawsuit or it could allow it to go forward. There were very few rules. Now, if a country had good diplomatic relations with the US, it was likely to enjoy immunity. But if not, you can imagine what happened. So this sort of highly discretionary, capricious system prevailed for a very long time, and it led to all sorts of diplomatic problems. But starting in the 1950s, the State Department tried to create some rules to govern its decisions about immunity. And of course, the key thing it adopted was the restrictive theory of sovereign immunity. And as I think you already know, this means that a foreign sovereign will be deemed immune from the jurisdiction of American courts, except with respect to claims arising out of activities that are of the kind that could be carried on by a private individual. So if it's sued for doing something an ordinary individual or corporation might do, it is not immune. This, in essence, is trying to draw the line between public international law and private international law. And this turns out to be a very, very hard line to draw in practice. So the State Department it gave itself some rules, but it still found itself in the middle of the immunity determination between about 1950 and 1976. And it was getting political pressure and pressures from foreign governments to make decisions one way or the other, and it was having a hard time drawing these lines. So in 1976, the State Department basically drafted a statute, sent it to Congress, and Congress enacted it. It's called the Foreign Sovereign Immunities Act. We call it the FSIA. And what it did was try to take the immunity decision out of the hands of the State Department, out of the executive branch, and put it in the hands of the judiciary. Now, the State Department to this day still occasionally gives its opinion concerning immunity issues that sort of specifically touch on American national interests, but it's pretty rare. Today, the people who make the decision are individual judges, and this has been true since 1976. Well, this has had the advantage of depoliticizing the immunity question. On the other hand, it has left the immunity issues, which are tricky, to judges who generally lack any familiarity with foreign sovereign immunity law, at least at the trial court level. So even today, claims against foreign sovereigns are fairly uncommon. And so a typical federal judge, you might see 2 or 3 of them in his or her entire tenure on the bench. So in a 20 or 30-year judicial career, you might see a couple of these cases. Unless you're from specific jurisdictions like the DC Circuit in Washington, which tends to be, which for a number of reasons is a favorite forum, your average federal judge has never encountered these issues. And I can stress to you that American lawyers do not receive training in international law as a standard part of the academic curriculum. It's available, but it's not required. And so in many instances, judges are taking these issues totally cold. But let me give you, before I tell you how it works in practice, let me just give you the key attributes of the FSA, okay? So first, it starts with there's a presumption of immunity. From the outset of the lawsuit, the foreign sovereign is considered to be immune from the suit. And this baseline level of respect shown to foreign sovereigns is designed to promote comedy, and it reflects the way that the United States would like to be greeted in the courts of other countries. We'd like special treatment, so we grant it as an initial matter. But that comedy only goes so far. It does not mean reciprocity. You know, the FSA will not ask, for example, how the United States might be treated if it was brought into court in Ukraine. It also doesn't look, and this is I think personally a failure of the American judiciary, but we very rarely look to what is customary practice internationally and have our own, our system reflects something close to customary practice in some respects, but you will be hard pressed to ever find a decision in the United States actually looking to international practice in trying to decide any particular case. So the State Department, in drafting the FSIA, thought it could write down some nice, clear rules, hand the decision over to judges, and then judges would be able to easily apply these rules. But of course, it's easier said than done. The first and most important exception is called the commercial activity exception. It allows for jurisdiction over foreign states when the claim is based upon, one, a foreign sovereign's commercial acts that, two, either occur in the United States or have a direct effect in the United States. So it's dressed up as a commercial activities rule, but it is in fact the restrictive theory of sovereign immunity that the State Department initially adopted in slightly altered form. The word commercial there does the heavy lifting of trying to differentiate between the sort of public acts that a government might engage in and the sort of commercial acts that anyone ordinarily would engage in, that is to say, private citizens. To give you some examples of how hard it is to draw this line, we know as a matter of law in the United States, because there's a case from the Supreme Court on it, that if a government orders boots for the army and then doesn't pay for those boots, that's a commercial activity. Anyone can buy boots. It doesn't matter that those boots were intended for the feet of soldiers. But let's say a foreign government opens up an office in New York City to promote tourism and then doesn't pay the rent. That's governmental. Now, can't anyone rent office space? Don't companies promote things all the time? It is a fiendishly difficult line to draw. And what we are supposed to do is look to the difference between the nature of the activity, the government's activity, and its purpose. So we don't care what the purpose is. We look to see if it's a kind of activity in its nature that only a government could undertake. Now, the difference between nature and purpose is getting pretty metaphysical. You know, I have a degree in philosophy, but you would have to be Socrates to apply this faithfully. The commercial activity exception has proven so difficult to apply and so easy for plaintiffs to manipulate that it is raised in practically every case against a foreign sovereign in the United States. And I'll tell you what really happens. Most of the time, the issue boils down to geography. Is the claim based on something that the foreign sovereign did at home in its own country? Well, then it is less likely to trigger jurisdiction. But if it has any connection to the United States, and these connections can sometimes be very tenuous, if it's commercial in nature, it either occurs in whole or part in this country, or has a direct effect here, there's likely going to be a finding of jurisdiction. Now, why has this devolved into a geographic test? I think it's devolved into a geographic test because the United States has 50 states. We have 50 little sovereigns underneath a federal government. And as a result, federal judges, when they're running their jurisdictional analysis in typical cases, are concerned about geography. That's where they run home to when making these decisions. So they see the perplexing nature versus purpose test, this distinction between public international law and private international law. They get scared and they answer the question by resort to a simple analysis, geographic. So what is a direct effect in the United States? So if a foreign government contracts with an American party in the United States and then breaches, that breach is a direct effect. But if an American party contracts with a foreign government abroad, like where was the contract formed, the breach only has a direct effect in the United States if the contract specifically contemplates payment in this country. Now, so for example, Argentina made a big mistake when it issued bonds specifically providing that payment would be made in New York City. When Argentina defaulted on its debts, American bondholders were able to seize Argentina's assets in this country, some of them. Another, of course, important exception to immunity is waiver. It's comparatively straightforward. It is a very typically invoked way to establish jurisdiction, but I'm not going to go into it here. Expropriation is a very hot topic these days in sovereign immunity law in the United States and has become a big issue for Ukraine. Just last week, we had a decision come down favorable for Ukraine in the United States Court of Appeals for the District of Columbia Circuit. This is the court just below the United States Supreme Court. So basically the rule is this: a foreign sovereign can be sued in the United States for expropriations, but only expropriations that violate international law. And that phrase, violates international law, does a lot of work. It says, in essence, that if a sovereign expropriates from its own people, then it's not actionable in the courts of the United States. But if the sovereign expropriates from citizens of the United States or some third country, then jurisdiction may lie. And so the case last week, which is called the Ivanenko or Lux Express case, involved a group of companies that had substantial real estate investments in Kiev, and they claim that the city terminated their leases and their property was destroyed in connection with the construction of a railroad bridge. They sued in the United States because they had left Ukraine claiming political asylum, and that the essence of the claim was this: that the United States has carved out exceptions to this requirement to show an international taking, to show an expropriation. For some instances like genocide, we've confronted cases arising out of World War II and Nazi Germany, and courts, because they're sort of organically making this law, have said, well, we're going to allow cases involving stolen artwork from Jewish families to proceed, even though they were German at the time. But the real reality is they weren't being treated as Germans. And so they sort of eroded the idea of what it meant to be a national of one country in order to be able to expand the scope of the exception to immunity. Well, the Ivanenkos, the plaintiffs in the case against Ukraine, claimed that they were the victims of anti-American bias because their company had very close economic ties with companies in the United States. And they claimed that the regime then in power was biased against them. And so they tried to claim that the expropriation exception should be expanded to cover their sort of discriminatory takings. Well, fortunately, the DC Circuit agreed with us. And importantly, it was following a recent decision by the US Supreme Court. Sorry, I'm just reading these texts here. And the basic reasoning was this. Justice Roberts, the Chief Justice, explained that if we in the United States allowed claims to proceed against foreign sovereigns on the grounds that the taking was discriminatory, that the United States would open itself up to claims across the world for all of its misconduct. You know, it pointed out that the United States does not come to the international world with clean hands, that we have a history of slavery, a history of mistreatment of Native Americans, and many other sorts of misdeeds in our national history that could be actionable in foreign courts. And so the United States has decided, or the judiciary has decided, to stand back and not allow any claims to proceed from takings from a country's own citizens. So all of those cases involving Nazi Germany have now been, or can never be repeated going forward. The last decision I want to talk about very quickly is an interesting case about the tort exception. There was something added as an afterthought to the FSIA that allowed for claims against, they thought it was going to be consular officials and other foreign nationals who might get involved in car accidents and other sort of small level torts in the United States. But the Democratic Party, Joe Biden's political party, sued Russia for tampering with American elections. And unfortunately, the court concluded that Russia was immune from the claim. It reasoned that the tort, which was cybercrime, did not occur entirely within the United States. I mean, part of the crime occurred in Russia. And so it felt that the tort exception, which requires that the tort be committed in the United States, did not apply. Now, this decision has been highly unpopular, as you can imagine, and there have been calls to reform the FSIA to allow courts to address issues like cybercrimes. But it is, and this is my concluding thought, it is an example of how a statute that gets codified in 1976 didn't contemplate anything like the sort of modern world in which we live and the deeper interconnectedness that we experience today. And so it is ill-equipped to deal with the modern realities of courts being committed at a long distance. Anyway, I would like to thank you all for your attention, and I appreciate it. Thank you.
Thank you, Robert Shaw, for this presentation. I think that there is a question addressed to you, or is it addressed to everybody?
Let's see. When it comes to international law, is it okay for a country to receive an international criminal for medical reasons, in addition to the fact that lawsuits were filed from the same country and other ones also? It's an interesting question about receiving an international criminal for medical reasons. I've represented the government of Ukraine in a case that involved former Prime Minister Lazarenko, who fled Ukraine, came to the United States, and was promptly arrested, jailed, and convicted. He and his associate Girenko have claimed medical reasons to avoid extradition back to Ukraine. So this is an issue that's going on currently in the United States. The interesting thing is that under American law, he's been tried, convicted, and served his time. So he's not, I guess, an international criminal in our minds, but I'm not certain of that.
Okay, thank you, Robert, so much. I have a follow-up question for you because, so thank you for covering all the exceptions. And so correct me if I'm wrong, but the understanding is that the question of sovereign immunity and the exceptions to it are regulated by the Act. So the courts really do not have lots of latitude in establishing their own rules, right? And so the case with the cyber attack exception didn't work because it was not in the Act, right? Is this correct? Is this the right?
That is, Svitlana, that is 100% correct. But of course, the way our common law system works is that the statute, and the FSA is pretty short, gives sort of general principles for the courts to follow. And then over time, courts interpret the statute, apply it to individual decisions, and create an entire body of law that informs everyone's thinking on what the statute means. So a judge can't directly contradict what the statute says, but if there's any room for distinguishing the statute, courts do often go out and venture and make their own law if it's consistent with what other courts have done in the past.
Thank you. And so before we move on to our last but not least speaker, let me, I'll just exercise my discretion as a moderator and ask you to clarify on one last issue, just because I think that this is important for Ukrainian endeavors in deciding how to go with a restrictive approach to the question of sovereign immunity. The commercial activity exception is absolutely the most important exception, and of course I'm pretty much sure that if Ukraine goes the road of enacting the relevant law, the commercial activity will be there, but it all narrows down to the criteria as how to apply it, right? And you've mentioned the whether the courts look at the purpose or whether the court looks at the nature is the question which really decides the matter. And we also know that the United States position and the European position sort of differ with this respect. And this is one of the reasons also why any universal, I mean, why there are treaties, but not all of them have been ratified or accepted by the states, precisely for the reason they disagree on what criteria to apply when looking at the commercial activity exception. And you mentioned this interesting case about the boots. So if the government has a contract for buying boots, even if they are the boots for the army, for the United States, it would mean the commercial activity exception blatantly. And these state will be open to the jurisdiction in the US courts. This is a very interesting example, but we know, and Ukraine faced a very interesting issue when its law enforcement bodies, the Ukrainian Prosecutor General Office in particular, entered into, well, it's debatable whether it entered, but for the US court, it entered into a contractual relations with the US company for law enforcement activities, for finding money. And the US court did not find that Ukraine in this particular case enjoyed any immunity from jurisdiction. So can you say a little bit about this case, please, and how this nature, purpose, really criteria worked in the commercial activity exception?
Of course. In that case, the UPGO had contracted with an American company to help track down assets that had been misappropriated by a former Ukrainian politician. And the American company proved hopelessly incompetent at the task, and then sued when, despite not finding any assets and not repatriating anything to Ukraine, it claimed that its efforts had been stymied because the Ukrainian government hadn't cooperated enough in its efforts. We asserted immunity on behalf of Ukraine and argued that, trying to track down the assets misappropriated by a former government official is as quintessential a government activity as you can imagine. It's a law enforcement activity, and we're essentially hiring this investigatory company to help the Ukrainian government fulfill what is clearly a governmental purpose. No, in its nature is inherently governmental in its nature. And the First Circuit Court of Appeals, not a court that sees a lot of immunity questions, but an important court, held against us, unfortunately, on the immunity issue. And it concluded that, companies and individuals hire investigators all the time. People are out there trying to track down stolen money or trying to track down debtors all the time. This company in particular that had been hired claimed to offer its services in the private market, equally as much as to governments. And so they looked at the nature of the activity, investigatory services, and said that despite the fact that its purpose was clearly governmental, that didn't make any difference. So the court had found there was jurisdiction over Ukraine. Fortunately, we were able to greatly reduce the exposure on the merits because the claim had other problems, but it did manage to make it past the jurisdictional test. And out of the 4 cases we've defended for Ukraine, it's the only one that the plaintiff managed to establish jurisdiction. Thank you.
Okay, thank you. Thank you so much, Robert. If there are no questions, and we lag behind a little bit, so let's move on to our final presentation, because I think that it's just logical after Professor Gnatovskyy remarks about the private-public distinction, how it got blurred, and Robert's remarks on the US practice, based on the blurred lines. The natural question is, where is Ukraine in all this? What is our position? What is our standing in this legal development? What has been done in past? What should be done? Probably what is the direction which the Ukrainian legal community and policy scholars should be moving forward? And so we are very lucky to have with us an experienced Ukrainian international lawyer and former diplomat who not only had to deal with these matters firsthand in his professional life, but who also have extensively researched this topic as part of his dissertation project, and is undoubtedly one of the pioneers in the field. So let me welcome Oleksandr Girenko, who we believe is best positioned to reflect on past and recent developments of the doctrine of sovereign immunities in the Ukrainian legal discourse. Oleksandr, are you with us?
Yeah, I see that Oleksandr is with us, but his microphone is turned off.
Okay, I will shoot him a message.
Hi. Yeah, so Oleksandr, we hear you.
Okay. Let me start over. Thank you, Svitlana, and I'm glad to take part in this meeting. It would be fair to admit that my expectation for the successful implementation of restrictive immunity theory in Ukraine were rather small. As you know, the active development of the restrictive immunity theory began in the second half of the 20th century, and in Europe, the locomotive for this process were both the doctrine and case law. Robert made a good point about the US history, and he didn't mention it, the Tate letter that contributed the most, I think, to the spread of the concept of restrictive immunity in the United States. And well, at this time, Ukraine, which since the beginning of the 20th century was part of the Soviet Union, enjoyed the absolute immunity theory, and this theory was totally dominated in Ukraine. The Soviet doctrine was based on the fact that the principle of state immunity derives from the principle of sovereign equality of states, and the only exception to this rule can be an explicitly a waiver of immunity. And the relevant norm was enshrined in the Civil Procedure Code of Ukraine of 1963, and according to which filing a claim against a foreign state, securing a claim, and the execution of a court judgment could be allowed only with the consent of the competent authorities of a foreign state. And until the end of its existence, the Soviet state strictly adhered to the absolute immunity theory, which was fully reflected in doctrine and practice. And legislation based on absolute immunity has been inherited by Ukraine. And despite the radical change in the model of private law relations in Ukraine since 1991, no significant adjustments have taken place on the issue of jurisdictional immunities of foreign states. And due to the explicit nature of the legislation and the absence of so-called large cases in which the defendants would be foreign states, and the case law was not extensive as well. And for example, in 1999, the Supreme Court of Ukraine overturned a judgment of a lower court by which the Russian embassy was ordered to compensate a citizen of Ukraine for damages caused by a traffic accident involving an embassy's car. And an attention to enshrine in Ukrainian law a rule on Ukraine's waiver from jurisdictional immunity was made in 1999 when the law of Ukraine on production sharing agreements, according to Article 32 of the law, there was an obligatory waiver from jurisdictional immunities in the production sharing agreements concluded by Ukraine with foreign investors. However, this norm was declared unconstitutional by the Constitutional Court of Ukraine, as the court ruled that such a prohibition restricted the state's freedom to conclude a contract. In general, as Professor Gnatovskyy mentioned, the discussion about the possibility of abandoning the absolute immunity revolved around the fear that in this case, Ukraine would not be granted immunity abroad. To what extent this is justified is an open question. As of today, the general norm regulating the issue of jurisdictional immunities of a foreign state is Article 79 of the law of Ukraine on private international law. It provides the following. The institution of an action against a foreign state, the involvement of a foreign state as a defendant or a third party to the action, the attachment of property that belongs to a foreign state and is located on the territory of Ukraine, the application of other measures of securing a claim and application of recovery to such property may be allowed only with the consent of the competent authority of the respective state, unless otherwise provided by an international treaty of Ukraine or the law of Ukraine. A relative novelty compared to the Soviet approach is the paragraph 4 of Article 79, which provides that in case when contrary to the norms of international law, Ukraine, its property or agents in a foreign state are not jurisdictional immunities which under the article are guaranteed to the foreign state, their property and agents in Ukraine, the cabinet of ministers of Ukraine may apply the corresponding measures allowed by international law to that state and its property. However, the practical implementation of this rule is not completely clear, but as usual, life itself makes a difference. After Ukrainian companies began to obtain arbitration awards in their favor in cases against the Russian Federation regarding expropriated property in Crimea, the question arose about the execution of these awards. And in September 2018, the Kyiv Court of Appeal, as a court of first instance, granted 2 applications of Everest LLC and 17 other plaintiffs for recognition and enforcement of the Everest Award in Ukraine, as well as for provisional measures. The appellate court granted the motions and seized the shares of Russian state-owned banks in their 3 Ukrainian subsidiaries. And in this respect, the Kyiv Court of Appeal had to consider whether the Russian Federation had immunity from execution of a court decision, as it's required by Article 79 of the Law on Private International Law. However, in its judgment, the appellate court completely ignored both the existence of Article 79 and the question of the possible existence of immunities of a foreign state in this case. In this context, the Court of Appeal did not consider or verify the extent to which the institutions that are the beneficiary owners of 3 Ukrainian banks can be considered as a state, and whether they can be held liable for states' debts which are unrelated to their normal activities. These and other issues were raised by the 3 Ukrainian banks in the appeals, and in January 2019, the Supreme Court of Ukraine delivered an extremely interesting decision in the case. First, it upheld the decision of the Court of Appeal on the legality of the recognition and enforcement of the Everest Award. Second, it considered it possible to seize the property of the Russian Federation located on the territory of Ukraine and to ensure them execution of the arbitration award. And third, it established that the enforcement of an arbitration award against Russia in Ukraine is possible only at the expense of property that directly belongs to the Russian Federation and not to individual legal entities, and regardless of their nationality, Ukraine or Russian. Unlike the Court of Appeal, The Supreme Court of Ukraine addressed the issue of jurisdictional immunities of the Russian Federation in deciding whether to limit the absolute immunity of a foreign state in this case, which, as we recall, is guaranteed by Article 79 of the law on the private international law. The Supreme Court justified this possibility by applying norms of international law. The Supreme Court noted that also there are no national norms in Ukraine that limit immunities of a state, and Ukraine is not a party to either the European Convention on the Immunities of States of 1972 or the UN Convention on Jurisdictional Immunities of States and their property of 2004. These international instruments are applicable in Ukraine as customary norms of international law. And in support of this revolutionary position, the court referred to the case law of the European Court of Human Rights, where sometimes the jurisdictional immunities of a state were seen as an obstacle to the realization of the human rights to access to justice. As a legal basis for applying the case law of the European Court of Human Rights, in this case, the Supreme Court referred to the law of Ukraine on enforcement of judgments and application of the case law of the European Court of Human Rights. And Article 17 of which provides that Ukrainian courts should apply the European Convention on Human Rights and the case law of the European Court of Human Rights. This approach of the Supreme Court is quite creative, I think, in terms of the application of the at the national level of provisions of international instruments in the field of jurisdictional immunities, but debatable about the very possibility of implementing an international convention bypassing the established procedures. Another quite optimistic position in the decision of the Supreme Court that I would like to note is the conclusion of the court on one of the controversial issues of the restrictive immunity theory. Namely, does the waiver from adjudication, in particular in an agreement on mutual protection of investments, mean an automatic waiver from execution of an arbitration award? I believe the Supreme Court provided a rather simplistic answer. It noted that by agreeing to include in the BIT an arbitration clause and an obligation to comply with a possible judgment, the Russian Federation had ipso facto agreed to waive immunity in respect of itself and its property from adjudication, provisional measures, and execution. Such a conclusion may be based on a certain case law or maybe a comprehensive interpretation of the 1972 European Convention, which does not contain specific provisions on the relationship between immunities from adjudication and execution. However, the 2004 UN Convention still distinguishes between waiver from adjudication immunity and waiver from immunity from enforcement. And the Supreme Court, as can be seen from its decision, considers that the consent of the Russian Federation to implement the decision rendered based on the Ukrainian-Russian BIT is a clear waiver of immunity from execution. However, the court did not provide any justification or clarification for this position. Moreover, the court has in the file the written position of the Russian Federation that the Russian Federation does not waive its immunities, including immunity from enforcement. In general, the decision of the Supreme Court is excellent. It opens the path for serious scientific discussion and development of practical positions. Even in a rather narrow case of granting immunities to a foreign state during the enforcement of an arbitration award, a wide range of issues must be resolved, such as an amount of foreign states' properties that can be seized, identification of agents acting on behalf of a state and not on their own name, connection between the property of a foreign state discovered on the territory of Ukraine and the subject of the claim, possibility of execution from a property of a central bank and other financial institutions and so on. So as it's often the case in Ukraine, the Supreme Court's decision is based more on political motives. However, such motives in this case coincide with the objective reality, I think. And as for the future, I believe it's advantageous for Ukraine to accede to the 2004 UN Convention on the Jurisdictional Immunities of States and their property. And on the basis of this decision, the relevant legal framework and case law can be developed. No, I thank you for your attention and ready for further discussion.
Thank you, Oleksandr, so much, and thank you for covering the Ukrainian Supreme Court case. I really hoped you would. Are there any questions, colleagues, to Oleksandr? Because I certainly have a couple of questions, but I want to give you the chance to jump in.
Oh my God, I have a classic situation.
Oh, kids.
Yeah.
Future international lawyers.
So you can go. I'm so sorry, guys.
It's okay. Sure. Oleksandr, so
it was quiet for almost 2 hours.
Do you think I can ask you a question?
Yes, of course.
Yeah, of course. So my question would be, and I agree with you personally, and I don't know what the opinion of our colleagues is. Join us, but I agree that the case of the Ukrainian Supreme Court is basically or generally the move in the right direction. It's an excellent decision that it finally kind of openly recognized that there is the need for Ukraine to develop the restrictive approach to the question of sovereign immunity. However, of course, and you are right, and thank you so much for just saying what issues the Supreme Court did not really touch, which probably it should have to, and in this case, its decision would just have been more convincing. And I think that colleagues would agree that the Ukrainian Association of International Law, international legal scholars are very well positioned sort of to guide the Ukrainian judiciary with this matter. And Professor Gnatovskyy also mentioned that the doctrine is really poses many doctrinal questions. And I think that what this decision of the Ukrainian Supreme Court really implies is that there's just more guidance is needed. And you've mentioned that one of the possibility, of course, is to join the UN convention, right? I'm not sure if it's in force already, but anyway, of course, it will be, I think, yeah, it will be at some point, and we of course can make a plausible argument whether it's a customary law, coming back to what we have discussed before. But do you see any other ways how the Ukrainian policymakers and also the community of scholars can work on this issue? So, okay, we can ratify the UN convention. I don't think that ratification is open. We can accede to it. We can rely on the court practice, and we have the shining example of how it looks like. What do you think of the possibility of having the act similar to what the US has and to what Bob has also mentioned, the Foreign Sovereign Immunity Act? What do you think about that?
Thank you, Svitlana. Actually, it was my conclusion in my dissertation more than 10 years ago, and it's still relevant, but now we have some hope. I see that I think that accessing to the UN Convention is a great tool, because we will have the whole apparatus for this problem. We will have all these approaches that Robert told us about. And the second step is, of course, it's the special law. It's my opinion, and I think we can manage to do this, to draft the law, and it's not very complicated. It is complicated, but it's much better than leaving the issues to the judges.
Okay, thank you, Oleksandr, for this. So this is really something to think about for the international legal scholars. Maybe one final question, if I may, and thank you for your patience. And I think that we need to wrap up. But I can just help but addressing one final issue concerned with the Ukrainian Supreme Court case, and also the how Ukraine should be moving forward. One of the arguments, one of the reactions to the Ukrainian Supreme Court decision was that it makes Ukraine vulnerable to similar suits in foreign courts, right? And so I think that I will address this question to you, Oleksandr, and to you, Bob, and Professor Gnatovskyy, of course, feel free to jump in as well. How does this argument really sound? Is it convincing or persuasive? Especially, and we are talking right now, just let's narrow down the issue for the sake of time, to the situation when Ukraine is the party of the BIT with Russia, for example. So, and in this case, because this is, of course, which concerns us a lot, we want to give our investors the floor to be able to enforce the awards. So in case of the parties' signatures to the BIT, to what extent does the argument that we make ourselves vulnerable to similar lawsuits really work? So Oleksandr and Bob and Mykola, please.
Thank you, Svitlana. I actually can't remember any case in which the court said that it doesn't grant immunity because of the principle of reciprocity. So that's maybe the main answer for this question.
My experience is exactly the same, Oleksandr. The courts talk about comedy and the need to sort of act in a way that the US would like to be greeted in foreign courts, sort of follow the categorical imperative, the golden rule. But it never inquires as to how a foreign government actually would address the claim if the roles were reversed. So the policy consideration that Svitlana has raised, that is in adopting restrictive theory of immunity, is it going to lead to Ukraine being more vulnerable in courts abroad? I think the answer to that question, at least from the American perspective, is no.
Yes, and if I may just very briefly, I tend to agree with Oleksandr and Robert. I think that this argument is very much irrational, and it doesn't make Ukraine any more protected from suits abroad, because this is kind of a passive position that Ukraine has chosen. Maybe partially out of ignorance, partially because we just want to be on the safe side. But that never adds anything to our situation. So we have to be proactive, and we have to set the tone ourselves, rather than just try to make sure that we are not seen and not noticed by anyone. They will notice us, and they will sue Ukraine whenever they can, irrespective of what Ukraine is going to say on this. Thank you.
Thank you so much, colleagues. Do you have any any questions, which this is the very last moment, the very last chance before we wrap up, to ask any question to any of our speaker. And I don't see anything going on in chat, and I don't see any raised hands or anything. So, well, in this case, I would like to thank on behalf of the Ukrainian Association of International Law, I would like to thank all our speakers, all our presenters. Thank you so much for your valid contributions and for answering all the questions. So I do hope, and we hope that this is just the beginning of the discussion. We have discovered that there are many theoretical and doctrinal issues to work on, exactly what we've just spoke, to make Ukraine just have a powerful position. And just having the restrictive immunity approach doesn't have anything to do with the vulnerability in the contemporary world as it stands. And moreover, Ukraine especially has been a defendant in a number of suits abroad, and in many instances it was successful and defended itself on the basis of immunity arguments, but still. So I think that we all agreed that the right move for the Ukrainian legal community is to really help to work on the guidance on the legal arguments which our judiciary can have in cases which I'm sure it will certainly reach its docket sooner or later again. So thank you so much for your participation, and I think that we can wrap up if everybody agrees.
Thank you very much. Thank you very much.
Thank you.
Thank you.
So I finished this conference for everyone. So see you on our next briefings.
Thank you.